Hello friends, I hope you all are doing well, taking care of yourself. So let's continue from what we had seen in the previous session. So up till now we have worked on the historical and development part of the payment of wages and the definitions of establishment and wages in the Code on Wages. So starting with chapter 3 of Code on Wages, which discuss different provisions related to the payment of wages. First is section 15. What we have to see in this session is section 15, 16 and 17, which discusses different provisions related to the payment of wages. So the first one is section 15, which is titled as mode of payment of wages. Section 15 states that all the wages shall be paid in current coin, currency notes, check, or maybe through a bank, crediting the amount or the wages in the bank account, or by any electronic mode, transferring the amount to the employee. So the section explicitly or clearly states that it could be or it should be paid, the wages should be paid in current currency, current maybe coins or the notes, along with, or maybe crediting the wages in the bank account, or maybe by transferring the amount through any other electronic mode. The provision states that appropriate government will have the power to direct any industrial establishment to have the payment of wages in a particular manner, so maybe by check or by crediting the wages in a bank account. Other than this, next is section 16 and 17. Section 16 talks about the fixation of a wage period, and section 17 provides the time limit for the payment of the wages. So section 16 states, or it empowers employers to fix a wage period for the employees. Now the provision to this particular section says that there could be different wage periods for different kinds of establishments. Now section 16 states that employers shall fix a wage period, and it could be either, again section 16 clearly states that it should be either of the criterias or either of the classes which are classified within the section. So it says that the employer shall fix the wage period either as daily, weekly, fortnightly or monthly. Further, there is only one condition, which is that no wage period shall be of more than a month. So any wage period should not be of more than a month. That means the employer should pay the wages within a month, or the wage period should be of at least maximum 1 month. 1 month, not more than that. So it further says, section 17 further says that what should be the time limits for the payment of wages. Yes, section 16 provides us that the employers can either pay pay the wages on daily basis, or maybe on a weekly basis, or fortnightly, or maybe monthly. But the time limit for the same is provided in section 17. Section 17 states that in case of a daily engagement, the payment of the wages for such daily workers should be made before the or at the end of the shift, before the commencement of the next shift, or maybe at the end of that particular shift. So if a worker is working from maybe 9 to 4 or 9 to 5 in a particular day, before the end of the shift, that means if it is ending at 5, the employer has to pay such worker who's engaged on a daily basis the wages for that particular day. Next is the weekly engagement. In this section 17 provides that on the last working day of a week, the payment of wages shall be made. That means before the commencement of a weekly holiday. So if a particular working week for an employee is from Sunday to Friday or Sunday to Saturday, the worker should be provided the wages on Saturday itself, because Friday itself, because on Saturday they will be having the holiday. So this section 17 says that before the commencement of a weekly holiday, or at the end of, or on the last working day, the payment of such workers who are working on a weekly engagement should be made by the employer. Next is fortnightly engagement. Fortnight means a period of 2 weeks. So this particular kind of class of wage period, section 17 provides that before the second day after the end of the fortnight, the payment shall be made. So fortnight is, as I just said, it's a period of 2 weeks. So if any worker is employed on a fortnight basis, or maybe 14 days for 2 weeks, or maybe with some holidays in such 14 days span, so then before the end of the second day after that fortnight, so if it's the duration of 14 days, after that there could be 2 more days, and after that or maybe before the end of that particular second day after the fortnight has over, the payment of that wage should be made by the employer to the employee. And the last one is the monthly engagement. Monthly engagement, or the workers who are working on a monthly basis, their payment should be made before the expiry of the 7th day of the succeeding month. So if I am working on a monthly as a monthly wager or monthly employee, my payment should be made at least before the 7th day of the succeeding month. So like from 1st to 30th is 1 month, and then the next month before the 7th, the date 7th day, the payment of the wage shall be made as per section 17. Beyond this, section 17 also provides that in case of removal, dismissal, retrenchment, resignation, or unemployment due to closure, in such cases, if any employee's service is being terminated, the payment of the wages of such employee shall be made within 2 working days of such removal, dismissal, retrenchment, or resignation. So section 17 clearly states that if anyone is removed, or if anyone is dismissed, or if anyone is retrenched, if anyone has resigned, then in that case within 2 working days of such resignation, such termination, that means retrenchment or dismissal or removal, the payment should be made. Now here you'll have a confusion, why do we have this 4 different kinds of the removal or termination mentioned in section 17. One is removal, one is dismissal, one is retrenchment, and one is resignation. You already know what is retrenchment. We have already studied that in labor laws 1, right? So termination of the service but not on account of misconduct is the retrenchment. Dismissal means termination of a service which may have the reason of misconduct or any other reason by virtue of which the employer has removed or dismissed someone from the service by way of which is a kind of a punishment for the worker for not working appropriately or in consensus with the codes and regulation of the employer. Removal could be a temporary removal, maybe for a particular period when the employer is not requiring any workers, then he may remove. Or maybe a removal could be a kind of a transfer from one particular place to other place, or removal could be from a designation that a particular person has been appointed as maybe as a front desk officer, and he's been removed from that position and has been given some other position, right? So that could be considered as a removal. Or removal could be because of the maybe non-requirement of a worker in the employment. And designation, as we all know, means resigning from the service. So in such cases, within 2 working days of such removal, retrenchment, dismissal, or resignation, the payment of the wage shall be made by the employer to the employee. Now here the one another clause is that the appropriate government may provide other time limit for the payment of the wages if any state government is of the opinion that the time limit should be maybe beyond this particular duration or lesser than this particular duration, then that could also be done by the appropriate government for any case. Now other than this, what section 17 exactly says. See, there is like within this particular topic there is something called responsibility of a payment of a wages. Section 17 implicitly states or imposes a duty of payment of wages on the employer. What it says, like the wordings of the section 17 is that the employer shall pay or cause to be paid wages to the employees, and then there are other, like, further things. So it says that, implicitly employer shall pay or cause to be paid the wages of the employees to the employee. Other than this, there is one section 43 under chapter 6 of the code on wages. Now section 43 states that, or it makes explicitly employers liable for the payment of the wages of the employee. What section 43 states that the employers are liable to pay all the amounts which are required to be paid under the code to the employees employed by him. Further, the provision of this section says that in case of failure of any employer, the company, firm or association or the proprietor of the establishment shall be responsible for the payment. That means if the employer is merely an employee of one particular person, or company, or maybe a proprietor, then in that case the principal employer would be considered responsible in case if the employer is failing to pay the wages of the employee. So reading section 17 and section 43, it gives us an idea that the responsibility of payment of the wages is imposed on the employer. Section 17 implicitly imposes the duty of or responsibility of payment of the wages on the employer, that employer shall pay or cause to be paid wages to the employees, and section 43 states that employers are liable to pay all the amounts which are amounts to the employee which are required to be paid under the code on wages for the employees who are employed by such employer. And then it further provides that in case of any employer or in case of failure of any employer, the principal employer will be ultimately held liable for the payment of such wages. Now let's say two cases within this. One is Cominco Binani Zinc Limited versus Pappajohn. In this case, Cominco Binani Zinc Limited versus Pappajohn, the citation is 1989 ILLJ 452. It's a judgment of a Kerala High Court. What happened in this case is this Cominco Binani Zinc Limited had provided and maintained a canteen within its establishment for the employees. Now the workers of this canteen were employed by a contractor, a third person who was looking after this canteen and establishment of the canteen and daily stuff and regular requirement and everything of this particular canteen. Now these workers of the canteen had claimed that they should be paid some bonus and arrears which were for them like for the wages or for the for whatever wages were left to be paid to them. Now for this, the case went to the High Court, and High Court of Kerala, and Kerala High Court held the company liable because the company was a principal employer. The contractor who was looking after the canteen and the workers within that that canteen was a third person, or maybe like the first employer, but the principal employer was the company, because company had established or had caused this canteen to be established within the premises of the company. So it was held that the company is a principal employer, and being the principal employer, company has to pay company is liable to pay all the wages to the worker in case if the contractor is failing to pay the wages. Next is the case of case titled Payment of Wages Inspector versus Suraj Mehta. The citation of the case is 1969 AIR 590. What happened in this case is the MP State Electricity Board had revoked a license with one particular company, and after that, after revocation of the license, the company was it was took over by this particular board itself, and after this after this overtaking of or takeover of that particular undertaking by the board, the director of the company had served a notice to the workers or the employees that their services are not no more required now, and they should be they should leave from that particular establishment with whatever the deadline was given. So one of the employee, on behalf of all the other employees, had complained or had claimed the wages for 1 month's notice, because they have to be given 1 month's notice, as well as the retrenchment compensation, whatever the retrenchment compensation which has to be paid. The employee said that it should be, the wages for 1 month's notice as well as the retrenchment compensation shall be paid to us, because we are removed, or our services are terminated not on account of any misconduct, so it would be considered as a retrenchment. So the compensation and the wages for that 1 month's notice which is not being given should be paid to all the employees. Now the director who had given the notice, he contested that he was not responsible for any payment or any payment of the compensation. Reason being, the company was taken over by the board, the MP State Electricity Board. So whatever rights of the workers are there, the rights of those workers were defeated by the principal employer, the new employer, because the interruption of the service was because of that particular new employer. And after the company was, or after the undertaking was taken over by the new employer, this interruption of the service had happened. So that new employer shall pay the compensation, or whatever claims are there shall be made to such person. MP High Court was in favor of the director, and had held that the director shall not be held responsible, because director was just an employer and there was someone called principal employer, and now because the principal employer was now changed, that new employer shall be held responsible, and the same decision was upheld by the Supreme Court in this particular case. So by reading these two cases and by reading this provision, we can understand that the responsibility of the payment of the wages to the employees is solely on the employers. In case of the employers are working under someone else, maybe another principal employer, then such a principal employer shall be held liable to pay all the wages to the employees of that particular company or a particular establishment. So that's it for this particular session. In the next session, we shall see the provisions related to the deductions within the code on wages, and what would be considered as an authorized deduction, and what may be considered as an unauthorized deduction, and then the provisions related to further the deductions itself. So let's see that in the next session.